One of the things I think that it probably depends who you're talking to, whether it's an employer or a disgruntled employee. There's this feeling that the law seems to favour one group over the other. Mm-hmm. Is that the case?
It does depend on who you're talking to. If you speak to trade unions, they will say that the legislation is very much in favour of businesses. If you speak to a lot of businesses, they will say that it's all in favour of the employee. And of course, it's a bit more nuanced than that. Back to employment tribunal, if you go to an employment tribunal and you're an employer and you've done a dismissing, you might find that you're under quite a lot of scrutiny, because what the employment tribunal want to know, for example, you've dismissed me, I work for you, you've dismissed me for gross misconduct because you think I've taken £50 out of your petty cash. You're not very happy with me, you think I've robbed you, taking £50 of your money. But when you go to the tribunal, it's not me who's on trial as the person who may or may not have taken the £50. The person who is on trial, in inverted commas, is you, because what the tribunal want to know is not whether I took the £50, they want to know why you think I took the £50. And of course, that then focuses on the procedure you've gone through. Why did you suspect it? Did I get a chance to defend myself before you took a decision? And you might come out of the tribunal thinking, well, that seems a bit unfair because the focus was on me, and that might translate to a view that tribunals are fairly biased in favour of employees. And they're not. They just expect certain procedures to be gone through. So from a business perspective, if you've gone through perfectly reasonable procedures, rational procedures, then you're fairly well protected when it comes to employment tribunals. If you haven't gone through these procedures, then yes, you'll find yourself being criticised by the tribunal, and you will think that they're very much in favour of the employees.
So if an employer thinks that they're getting into a bit of difficulty around the area of employment law, it might be any aspect of it, at what point does it make sense for them to come and talk to someone like yourself?
I'm obviously going to say as soon as possible. I know from a business perspective that's a good business answer, but actually it's the correct answer. If you have an issue in the workplace, it probably could be dealt with very, very quickly. Some of them can be dealt with by a quick conversation. If they're allowed to fester, they can become bigger and bigger problems, and trust can break down between employer and employee. So if we get involved, we've got a lot of experience of dealing with businesses. We're not just lawyers. I'm not just going to read out the legislation. We've got a lot of HR experience here as well. So we could give you quite a good steer on where it's going and whether it's likely to escalate. If you're thinking of more formal procedures, so back to me stealing money out of your petty cash, it's a good time to speak to your solicitor right at the start, because if you get the process wrong and dismiss, you're very much on the back foot. If you get the process right, you can deal with any claim very robustly.
So if we use your £50, your employee stealing £50 or suspecting that your employee has stolen £50, is the point that you go and talk to a solicitor the point where you have that suspicion at first before you even talk to the employee?
I think so. That's the time you get decent HR advice. Now, decent HR advice might be from your in-house HR team, or it might be from solicitors. We work very closely with in-house HR teams, but at that stage, a lot of our clients would just pick up the phone, give us a call, use us as a sounding board. That's the time to be taking advice.